Welcome to this webinar about getting out of mental health and mental capacity detention. My name is Weston, KC, and I'm going to be chairing this session. We've got three excellent speakers for you today. This is just to let you know that the event is being live streamed and recorded. And the recording will be uploaded to our YouTube channel with the link and the slides sent to all the attendees. We've got a Q&A box there for you to put your questions in. And if you want to put the questions in as they arise, then when we finish the main part of the webinar, we will set to answering as many questions as we can. If your question is aimed at a particular person, if you could indicate that as that's helpful. So the aim of this webinar is to provide a clear, effective and practical guide for practitioners to enable them to navigate these sorts of cases. The webinar will provide an outline of the powers under the Mental Health Act 1983, such as Section 17 leave, conditional discharge, CTOs and guardianship, as well as the use of the powers under the Mental Capacity Act 2005 and the powers of the Court of Protection to facilitate discharge and give effect to aftercare in the least restrictive environment for those deemed to lack capacity. It's also going to examine how capacity issues might be resolved within the jurisdiction of the Court of Protection for those detained under the Mental Health Act 1983 and the interesting interdisciplinary issues that those cases can raise. So we've got three excellent speakers for you today. We've got Helen Curtis, who's going to be speaking to you she's an established Court of Protection practitioner, and she's going to be speaking to you with the benefit of her mediation skills as a qualified mediator, because she's often instructed in complex cases where there's a high degree of conflict between family members and health or social care services, and she also undertakes cases where capacity issues intersect with the operation of the Mental Health Act or across geographical borders. She's going to be speaking to you for about 15 or 20 minutes. Take it away, Helen.
Thanks very much, Amanda, for that introduction. Okay, well, welcome everybody to this webinar. As Amanda has said, it's going to touch upon the intersection between Mental Capacity Act and Mental Health Act. So just for some context, between April 2022 and March last year, over 51,000 people were detained under the Mental Health Act, and it may be a larger number than that given the cyber incident that the NHS had last year. In the Mental Capacity Act sphere, between 2022-2023, the number of applications to get an authorisation to deprive someone of their liberty increased to over 300,000. And out of those applications, only 19% were completed within the statutory 21-day time frame. So that's a little bit of the sort of numbers of people who we're being concerned with. In terms of the applications, it broadly correlates because last November, the statistics available said that there were just shy of 280,000 people aged over 65 who were living in care homes. And that accounts for just over 80% of all care home residents. At that time, there were available approximately just over 23,000 beds in psychiatric hospital. So obviously we know about the pressure on beds. So they're the numbers in terms of the people who we are trying to either help be discharged or live in the least restrictive care arrangements that are possible. And in trying to prepare something that I hope will be of some use to some of you, although looking at the experience in the virtual room, I feel a little bit intimidated. So I hope that you'll all feel encouraged to share your experience at the end of the presentation. But in order to focus on the discharge destination from detention under the Mental Health Act or under the Mental Capacity Act, where the deprivation of liberty is authorised, I felt it was important to look at how people come to be detained or deprived of their liberty in the first place. And what it seems, looking at the King's Fund research that's been undertaken, is that there are concepts of capacity, obviously, under the Mental Capacity Act, objection by patients or residents, treatment, and it seems that those concepts aren't universally well understood or consistently applied. There are geographical variations as well as differences of opinion within the healthcare sector itself. And that can leave people in a legal limbo without any access to the legal protection, the procedures that are available to ensure that detention and deprivation of liberty only happens when it's necessary, proportionate, and in terms of someone who lacks mental capacity, it's in their best interest. So this is the case that deals with a very real, concrete situation, the case of MC. And she was a person who, at the time of the application, had been living for quite a long time in a nursing home, but under Section 17(3) of the Mental Health Act, she still needed medication, but treatment was clearly available outside of being in a psychiatric hospital. And so there was an application for a conditional discharge, and it was adjourned in order that a standard authorization to authorize her deprivation of liberty in the nursing home pursuant to the Mental Capacity Act and the dole scheme within it could be arranged. And the first tier tribunal really regretted that it couldn't conditionally discharge her with conditions which amounted to a deprivation of liberty, and refused to discharge her. And that decision was appealed. And Upper Tribunal Judge Jacobs, he quoted from the Supreme Court case of MM, which made it clear that a tribunal didn't have the lawful power to deprive someone of their liberty. Quite the opposite. We're going to tribunals to try and get them to give people direct discharge and give people back their liberty. So there wasn't a power for a tribunal to discharge somebody, but simultaneously compel them to be deprived of their liberty. But what Upper Tribunal Judge Jacobs really focused on was the need and the availability for coordination to happen between the Court of Protection and the first tier tribunal. And he posed whether or not the Court of Protection could authorise a future deprivation of liberty once the first tier tribunal has granted a conditional discharge, and whether the first tier tribunal could defer its decision for that purpose were not issues which he said would be appropriate for this court to decide on. He was quoting, I should say, from that's what the Supreme Court said, excuse me, but he said in MC, well, I can, and he did, to force an element of coordination so that MC was thereafter living in the least restrictive circumstances. In a real live case that really exposes how these two acts can work, P was a man who had lived for over 35 years in a psychiatric hospital. He was a forensic patient. The various different sorts of violent offences, some of them sexual. And he had been conditionally discharged from the psychiatric hospital to a specific care home. And that was really as a result of a hardworking social worker who'd spent a lot of time not only getting to know P, but also to really understand the sort of needs and challenges that his care arrangements may require outside of a hospital setting. So the care home had been specifically chosen, and transfer happened and P moved there, and was willing in some sense to go because he was outside of the hospital, took his bags there, but never unpacked them in all those years that he was living there, because it's a relatively recent case. So sort of within about 4 years, so about 2021, when this was in court. And he hadn't unpacked his bags at all. He wanted an absolute discharge. He wanted to live free from any restriction. He was applying to the first tier tribunal for an absolute discharge. And he was living in the care home, subject to the usual conditions. I say usual, but conditions attached to a conditional discharge, obliged to live there, see his RC, community RC regularly, follow directions given by the community RC, submit for regular blood tests, things like that. But he lived there without any other lawful restriction depriving him of his liberty there. And it only really came to light because when the care home was invited to grant an urgent, then a standard authorization to authorize his deprivation of liberty there, because there was a risk, wasn't there, that if things deteriorated, he was now in his 70s, that he may have to be readmitted to hospital. And the whole point was to try and avoid that happening. He'd spent so long there. Social worker was very keen that this was something that did not happen. Happily, P enjoyed really a good degree of freedom. He went out at least 3 times a week, often more, for significant periods of time, took himself off into the town unescorted, unsupervised, for his lunch, went shopping. So on a day-to-day level, he was certainly free from continuous supervision and control, which is half of the acid test when someone's deprived of their liberty. So there was a query about, well, does he need a standard authorization? He's kind of freely coming in and out of this care home. But on closer analysis, it appeared that actually he wasn't free to leave completely. He had to come back, and certain steps would kick in if he didn't. And so in order partly to avoid him being returned or having a risk of being returned to hospital, the standard authorization was put in place. There was no dispute that he lacked capacity to make the relevant decisions. And so it sat, the standard authorization, alongside the conditional discharge. So looking at the need really for a greater understanding for how capacity is understood, it's noteworthy that the CQC, Care Quality Commission's report on the DOL scheme noted that I think they had response from not all providers when they were conducting this research, but they noted particularly in mental health settings, there's a variable understanding of the interface between the Mental Capacity Act, which is where the DOLs sit, and the Mental Health Act. And where both frameworks could be used, it is not always clear how staff decided that using the DOLS framework would be the most appropriate for a particular patient. And that's worrying, in my view, that the very people who sometimes are part and parcel of a patient or a resident's admission are also part of their discharge decisions or making their where they are the least restrictive. And for there not to be a clear understanding of how the DOLS framework operates is a bit worrying. And the CQC found a poor recording of mental capacity assessments. There didn't seem to be a need, it would appear from what they saw, that separate capacity assessments were needed for separate decisions. The regularity of review wasn't always evidenced in the paperwork, just to ensure that the principle of least restriction was in fact being observed. And any restrictive measures that had been in place at an earlier stage, if they were still there, whether or not anyone had thought about whether they were still necessary and proportionate. So all of those things would suggest that there's still a need for training, refresher training. There are very good training providers out there, but sometimes one wonders, are the clinicians or the healthcare professionals so busy doing the groundwork, or working on the ground, I should say, that time doesn't allow them to have this refresher training. So just a recent example from my own experience in a mental health tribunal recently, a responsible clinician for a patient was very clear that the patient had capacity. There was a brain-acquired injury case. The responsible clinician changed, different care team, very clear understanding that this patient lacked capacity. So within the space of a relatively short space of time, two responsible clinicians reaching opposite conclusions, and you have to ask, how can that be? And it's not clear how that came about, and whether or not there was a sense of what was the end point, what was the discharge planning around this patient. Because on one view, discharge planning obviously should start, according to the Mental Health Act, the code to the Mental Health Act, should start when somebody's admitted into hospital. So it's really worrying that further down the line, two responsible clinicians could reach opposite conclusions about that patient's capacity. So just another aspect of the way in which assessments are carried out. Just wanted to flag the relatively recent Derbyshire case, which I'm sure you're familiar with, that assessments that are being conducted remotely are unlawful. So I appreciate that it may have stemmed from the time of COVID, but it's very clear that where this was a case of a community treatment order being renewed over the telephone, and it's very clear that the court said an examination has to be a physical examination between the patient and the responsible clinician. So three cases that touch on the intersection between the Mental Health Act and the Mental Capacity Act. The Manchester case, initially decided by His Honour Judge Burrows in Manchester, was appealed by the local authority, and Mrs. Justice Thies upheld His Honour Judge Burrows' decision and the test that was applied when determining whether or not a person could be detained under the Mental Health Act. I'm not going to say very much more about that, because not only in the interest of time, but because I know James, who's going to speak after me, is going to deal with that in more detail. So looking at the case of the Cornwall case, this touches on the question of aftercare. Initially, this was a decision by Upper Tribunal Judge Church. Roger Pisani and Alex Schmidt, both from the mental health team here at Garden Court Chambers, appeared in this case on behalf of the patient. And this was someone who it was agreed by the responsible clinician that the risks posed could be managed in the community. But the difficulty was that the aftercare pursuant to Section 117 had not been sorted out. So initially, and it was agreed that a robust care package was going to be needed in the community, and without it, detention was going to be necessary. So initially, there was an application to adjourn to get more information, and that was acceded to. And then when the parties returned to the resumed hearing, things hadn't really progressed massively well. There was a potential placement that had been identified, but an assessment hadn't been carried out. But it did look as though it wasn't just a hollow option. It looked like it really might do the job. And in that situation, this patient, I should say, was still on PQ. So it was a bit of a jump to be saying community provision, but the application, the second application, where at the resumed hearing, was we're in similar situation. Please can we adjourn out until we have the outcome of the assessment? And the application then to adjourn was refused. That was appealed, and Upper Tribunal Judge Church said that looking at the tribunal rules, the Rule 2 for the overriding objective, Rule 5 dealing with the discretion of the tribunal's case management powers, decided that aftercare for this person was completely key and needed to be looked at properly, and the tribunal ought to really have, looking at what the option was detention. So in order that a fair outcome could be achieved, that decision was set aside and it was remitted back, and for obviously the assessment to have taken place and for the least restrictive option to have been made available for the patient. The next case is the case of ML and Priory Healthcare, another case, I think, by Upper Tribunal Judge Church, if I'm correct. I'm just going to check. Yes, this was a patient in his 60s who'd been convicted for, there was a manslaughter, diminished responsibility manslaughter conviction. He was, I think, about 30 years past his tariff. He was a Section 4749 patient, and he sought conditional discharge. There was evidence that he lacked capacity to make a decision about where he would live and what care arrangements he would accept. And the decision to continue his detention was appealed, and the Upper Tribunal Judge Church said there'd really been a misapprehension by the first tier tribunal that there was no way for it to coordinate the Mental Health Act proceedings with a standard authorisation under the Mental Capacity Act. And that really highlights the decision of MC by Upper Tribunal Judge Jacobs that I mentioned at the beginning. And Upper Tribunal Judge Church really was saying, firstly, yes, there is a way of coordinating it, and she made some case management directions so that when, after that decision had been set aside and it was remitted back, there was real focus on what needed to happen. And I think that it included the attendance of a senior person from the local authority to give evidence as to how the aftercare was going to work, how the aftercare provision was going to work. Just touching very briefly on these three items, Section 17 leave. I've already mentioned about circumstances where there's long-term Section 17 leave. There's a case here which dealt with a similar situation, living in a care home, supervised leave in the community, but in that situation, that person had not been inside a hospital for almost a year, so it was not appropriate that they would remain liable to be detained because the care package that they were receiving didn't include a significant component of hospital treatment. Section 17 leave is obviously used by a responsible clinician and can be used very sensibly to test out or to trial somebody's move into a new placement before they're discharged. Obviously, that can happen with or without the involvement of the tribunal. But without it, but without it, some judges or some tribunals are reluctant to really feel confident about considering a less restrictive environment. So it is used, but obviously long term, it's now there is a tendency to look more favourably towards the DOLS framework, in my experience. Community treatment order, you may well all be very familiar with this. Obviously, to have it to be discharged from one, it necessitates an application to the tribunal, but it demonstrates that this is for a patient where it's not necessary to be detained in hospital. And so being in the community and having a community mental health team around them is obviously key. But there are some worrying statistics about the use of community treatment order and how, when one looks at either the age or the ethnicity of those who have a community treatment order, one questions the disparity, the reasons for the disparity of its use. Again, with similarly, rather, with guardianship, this is almost seems a little bit out of favour from use by local authorities. I've only got currently one case that involves the guardianship, but because it doesn't include the element of being liable to detention, and then it's a kind of light touch, really. But it is useful. It can, in certain circumstances, be used alongside a standard authorization, depending on the particular needs of P, if it's a person who lacks capacity. And that's the one case that I have at the moment where guardianship is sitting unusually alongside a standard authorization. So I'm just checking time, and I just wanted to end really with this last word. It's Mr. Justice Mumby, and it's before some time ago now, but it's about risk. It's about whether or not are we looking to achieve somebody's happiness, not achieve or prevent that happiness or the possibility of that happiness or the degree of that happiness being achieved by the use of a less restrictive measure. Less restriction being having treatment outside of a hospital setting. And on that, I remember Upper Tribunal Judge Church again in the SF case, I think that's SF against Avon and Wiltshire, where that in that case it was significant. Another one of Roger Pisani, I'm giving him a few name checks here, where the young woman, I think, was PTSD and autistic spectrum disorder, or an autism diagnosis. And what was said in that case was the treatment wasn't restraint, and restraint at times was needed, but there was an understanding in the SF case that the treatment that was needed was psychosocial, and it wasn't available in the hospital setting. And so there's a real concern about, well, if the treatment, which is meant to be available treatment under Section 145 of the Mental Health Act, if that's not available when you're looking at the statutory criteria, how can you continue to detain someone just because there isn't an option? Whereas in fact, there can be an option if tribunals are open-minded at looking at less restrictive option. And that sort of ties in really with a management of risk, but also not removing risk so completely that a patient or a resident ends up living fairly miserably. So I was trying to end on a happy note with the promotion of the happiness for P and the discharge availabilities for patients detained under the Mental Health Act, where there are less restrictive care arrangements available to them, and therefore the necessity of remaining in hospital falls away. So I think that's all I'm going to say. I will stop sharing and hand over.
Actually, I'm just going to introduce James, if I may. So thank you very much for a really thorough and absolutely engaging summary of the case law, Helen. And James Holmes specialises in children's law, court of protection, international family law, financial remedies, and public access family law. Because he's got such a deep background in family proceedings, James has also been able to develop a successful practice in representing vulnerable clients and their families in a wide range of health and welfare cases. James is going to speak to you now for about 15 or 20 minutes. Thank you. Take it away, James.
Thank you, Amanda, for that introduction. I'm just going to seek to share my screen. Thank you again. So my part of the seminar that we're going to discuss now is young persons. As I say on this slide, this is a very, I'd say, complex area of law. That's as a result of the overlap that goes and happens in respect of a number of statutes due to the ages of the people who generally come under this area, which includes the Children Act 1989, the Care Act 2014, the Mental Capacity Act, and also the Mental Health Act. When you add to that also the various statutory instruments, the accompanying guidance, and as I say here quite clearly, the lack of suitable placements which young people can be accommodated in post-discharge from, for example, a CAMHS Tier 4 bed or a secure placement, it's quite a complex and sometimes difficult area. As I also mentioned, an added difficulty, as I think touched upon by Helen, is the professionals not working cooperatively, and I sometimes would say collaboratively with one another to work out the best options for these young people, to try and work out and find them suitable placement and put in the correct level of support. Helen has touched upon, and I will come to it later, the Manchester University case that went on appeal from His Honour Judge Burrows to Mrs. Justice Tice at the end of last year. But that I would expect to gave quite a stark example of the need to for people to work together cooperatively. Another thing that always I'd say adds another level of complexity is the fact of the responsibilities and the changes in the responsibilities that happen between someone turning 16, 18, and also 25 when you are factoring into young people who are under different teams in local authorities, and also the young people who have the benefit of an educational healthcare plan, who will have placement and provision provided under that, which some will continue until they are 25. So there's all of these interchanging, watching and making sure and observing, make sure everything is right. And I put the quote from Hannah Judge Hilder from the case of Bolton versus KL 2022, when she noted that it's become more and more common now. I think in that case, she said 4 to 5 a month at least of 16 to 17-year-old cases that she's having to deal with, and a number of other specifically allocated judges at First Avenue House to deal with such cases. Another, and just in other stat I just want to put out there, is that we all are aware of, and I will highlight again, the National Deprivation of Liberty Court in respect of young people that was set up, and in respect of statistics in respect of those applications, there's earlier this year they were saying end of last year was 117 applications per month, and in the whole of 2023 there's 1,368 applications involving children. What I'm unable to say to anyone here is how many of those cover situations of children who have mental health conditions, mental health disorders, transferring out of secure either accommodation or mental health hospitals, Tier 4 beds, and trying to be put into suitable accommodation post-placement, because unfortunately the statistics don't go that far. Sorry, skipped one slide. Dealing then with the first question, I would say, and one of the more difficult questions it can be, is does the young person we are dealing with lack capacity? That is, I think, the first question, and we should all be asking ourselves when we encounter such cases, as that has an impact upon the routes which would be available to anyone looking at to safeguard these young people and putting in least restrictive placements and identifying placements. What, as I highlight on here, it's not always a straightforward question. There's, because of the issue in respect to fluctuating capacity, but I think the more difficult one, and I think Helen highlighted one of her case in her slide, but it's an issue, is distinguishing between a young person, and same with the adults, who lack, the ones who are making decisions who lack capacity, and also the young people who make decisions which objectively we would regard and would be regarded by others as unwise. That, I think, is something that it's become more and more difficult and troubling for the courts, knowing, for example, you've got when people are doing certain things which we would want to safeguard these young people from, but then it's getting to a point of when is the court being involved too much? When should the court step back? The difficulty with capacity is also highlighted by the Manchester case, that the Manchester case involved 17-year-old young person. That young person at the very beginning of when proceedings and the relevant history had been found out she did have capacity to go into under Section 2 into Mental Health Act. Subsequently, later on, she was transpired that she then lacked capacity to make decisions. And that just shows you how actually throughout the case, when you are working with such people in these sort of cases, it needs to be kept constantly under review. That the issue in the Manchester case was that they concluded she lacked decisions in capacity in respect of making decisions about her care, the treatment she needed, where she needed to be residing. So that is a difficulty with that one. So my observation in respect of this is it is very important in these cases finding and identifying the correct people to give you and help you with identifying whether that young person or young people the young person has capacity, and generally that will require an expert. And when looking and considering capacity, it's making sure, and if we remember, they are decision specific questions that you would have to be asking. And just because, for example, you have capacity, certain as we all know, you don't have it in all of them. The certain questions you would be asking yourself is whether that person has capacity to decide whether to remain in hospital, what restrictions should be in place once that person leaves or was discharged, and the medical treatment that should be provided to that young person. The other thing in respect of capacity, and I think is quite important, I would say, of young people, is that the training and providing them information to enable them to gain capacity or assess the capacity. I would say this is quite a relevant question, especially certain young people, and definitely some of the questions we are asking is making sure they have been provided with the right information to at least try and obtain and understand that information prior to any sort of capacity assessment. And that is what I would advise in respect to that. If you've got an expert identified, asking them specific questions beforehand to make sure that is provided. And the other thing I would say in respect to young people is considering what provision, if anything, can be done educationally. You have some of these young people will have educational healthcare plans. Those educational healthcare plans can provide the people with the ability to learn life skills, ability to function and work in function in society and understand certain aspects. And then it's seeing whether aspects of that can be included within the plan to see whether that young person would actually obtain the relevant capacity in the questions that are being asked. As the next topic I just want to discuss with those and just highlight is the appropriate tribunal, which is the appropriate tribunal for matters to be in. And as you can see, I've identified what I would say are the three relevant tribunals when looking at discharge from mental health. For example, a Tier 4 placement is you've got the Court of Protection, which is all, firstly, the issue with that is it has to be a young person over the age of 16, has to have deemed to have lacking capacity. And then under the Court of Protection, you have the RE-X procedure, the streamlined process, or the standard more the welfare hearings. And in my experience, at this moment in time, you're very unlikely to have a streamlined process in respect of a young person, especially if it's the first time it's going in front of the court, I'm particularly aware from my experience as Judge Hilda is very keen to grasp these cases and bring them before the court to make sure all the things are on track. The other court that other situation we have to decide whether the application should be made to is to the family court, in particular the National Deprivation of Liberty Court in the Family Division. That can be up to any child, a young person up to the age of 18, and it sets out there quite just the factors in respect to that. And the only other thing, and I don't think it would be rarely used, but there is the option in respect of young people under the age of 18 and the question of making an application for secure accommodation order. But I would struggle potentially to see how you would go from the mental health detention in a mental health hospital to then go into a secure accommodation. There may be exceptional cases, but I can't see that regularly happening in the circumstances. When I think anyone is looking at this question of what and where to make such applications, you have firstly the comment made by the then President, Miss Justice Mumby, in the case of ANF, that actually there is no hierarchy between the Mental Capacity Act or the Children Act to see which is the most appropriate court to make the application. And unhelpfully, one might say they run parallel to one another. So it is a decision really between the fact-specific decisions in the case that you are being asked to look at to decide which is the most appropriate tribunal. This position was confirmed in the Supreme Court in the case of Reedy 2019 by Lady Justice Black, in which was a case when the official solicitor had sought to try and persuade the Supreme Court that there was such a hierarchy, but she confirmed, Lady Justice Black confirmed and agreed by the court, the rest of the justices in the Supreme Court, that there was this parallel situation. So what do you look at, and what would I say when you are deciding which is the most appropriate court? A good starting point would be is the Mental Capacity Act. There's transfer proceedings, Order 2007, sets out a criteria of when matters would be transferred from the Court of Protection to the Family Court to the Court of Protection. That sets out a useful checklist, and certain aspects that I just highlight is there's questions in respect of continuity of judges, and what I would advise any of those looking at and considering is there are pros and cons to both, in the sense that if the matter was in the court and remained in the family court, and there were care orders, for example, put in place as well, which I will come to in a moment, you have the reviewing mechanisms on that. But then the downside of that is proceedings end at the point of 18, and there'd be a new application would have to be made to the Court of Protection. So there's pros and cons. There's no right or wrong answer. There were two cases that considered the question, and quite similar, I'd say, on facts, and two very different decisions by the High Court judges that dealt with those. One was Mr. Justice Hayden, and the other one was Mr. Justice Mumby at that time. So there's no right or wrong answer. Dealing then with the Manchester case, as I keep referring to, it was, to anyone who does not practice in this area, a shocking, surprising, upsetting, worrying sort of case to read. Anyone who was outside this area would struggle to see. This was a young 17-year-old girl, I believe. Yes, it was a girl, and she was being detained on a non-psychiatric ward, mixed adult ward in a hospital, following and the courts not being in a position, or the trust being in a position to identify a suitable placement for this young lady. And the issue that was encountered by Judge Burrow, His Honour Judge Burrows, was whether this was a case that could be dealt with under the Mental Capacity Act, or whether it was a case that should remain under the provision of the Mental Health Act. If Mrs. Justice Tice's decision is a lengthy decision, but is something I would recommend anyone who works in this area to consider and read. That the Secretary of State got involved, gave a number of suggestions of how to move matters on in certain cases when in this case they're saying there's this stalemate between what to do, and there's a set of options put forward which was endorsed by Mrs. Justice Tice about what is the appropriate way to deal with and what options a trust would have if presented in a situation that the Mental Capacity Act did not apply in certain cases. So I would invite those to read it. It's paragraph 118 of that judgment, which sets that out. But also what she usefully identified is what to do if you are wondering whether to make an application for court protection. She set out this list that I've summarised on the slide. What she did, though, also say, also in judgment, this is not an encouragement for her to make numerous applications to the Court of Protection to resolve this. I think she was hoping there'd be ways to be dealt without this having to have numerous applications being made and dealt with in the court, because as we know, it's already stretched. Just now touching upon, as I said at the very beginning, one of the biggest issues in this is identifying places for these young people. That we know there was a stark shortage of suitable placements. It's something that the President of the Family Division commented upon in the family case REX, not to be confused by the REX case in the Court Protection, REX 2023, in which the President flagged this issue, an issue that had been flagged by all the courts since 2017, and highlighting the stark issues that young people are faced with in this country, and the difficulties families encounter in what options are available. This issue is an issue faced because, as I said at the very beginning, the varying responsibilities that that are placed upon different bodies. Like there's responsibilities on local authorities, there's a responsibility on the NHS, there's a responsibility on the the Secretary of State for the Department of Education, all which require joint thinking, I would say, by those three organisations, but there is a lack of it, and which causes a difficulty in seeking placements. As I say here, but what can be done? There are a number of options highlighted here. The case of NHS Trust versus ST, that was a case from up north. I understand a case when Mr. Justice MacDonald was dealing with a case which concerned a 14-year-old child who had ASD modular learning disability, and at the time was detained on a paediatric ward. When I say detained, they had at points 10 security guards having to restrain her, a nurse having to come in and then sedate this 14-year-old because of the complex needs, and no placement could be managed, no therapeutic place could be managed. The stark, if not having spotted, it was an application made by an NHS trust. Those on this seminar might be going, well, why not the local authority? And that was the question Mr. Justice MacDonald said. The local authority, despite this young person being known to the local authority, were providing a social worker, but that was it in that sense, providing her support. So Mr. Justice MacDonald refused to make an application and made an interim care order for this child. The reason he did it on these facts would be the additional responsibilities placed upon a local authority, children under children's services, to find and establish, even if it's a bespoke placement for this child, so this child was no longer remaining on a paediatric ward. So I use that as an example because I would say it's going to be rare the local authorities aren't being proactive, but if they aren't, there is always that question, especially on young people under the age of 17, to see getting the local authorities involved to assist. And that may be very applicable with young people who might be might have been detained and were just not known to the local authorities prior to being detained. The Manchester case, I only point here as the point was and it's worthwhile, as I say, reading this case because it gives the example, and it was discussed. And this is actually the citation I have given here is the one to His Honour Judge Burroughs's actual judgment. Judge Burroughs, his experience in respect to mental health cases as well, highlights the fact that it needs to be reminded that whilst they may be conditional discharged or ready to be discharged, they have to be, young people or anyone has to be discharged into a suitable placement. It highlights the responsibility placed upon in the NHS under Section 117 and the obligation to seek and identify placements there. So that is the option that he highlighted. Then he makes a comment that sometimes that is forgotten about. I also make reference here to this question in respect of educational healthcare plans. I make this comment on the basis that there are these placements depending on what support needs to be provided to these young people. It's whether a consideration should and could be had to finding a suitable residential school that provides the support, the therapeutic assistance and provision that this young person needs. And that there are such schools, the consideration of that, and it's working out how that is to be placed upon a local. So it's just highlighting there is those options available in those circumstances. And finally, and it's one that I think the courts are very cautious about, is the creation of the bespoke placements. These bespoke placements, as the government has sought to rightly, I would say, restrict the use of where possible, are they're unregulated. This provides the situation in respect of who is to be of oversight. The family court, the president has been quite clear in light of the new guidance that has been issued. It's not the court's role, it's the role of, for example, Ofsted or the CQC potentially in certain aspects. And that is where these placements should always be encouraged to register. That what the other downside of these is, unless there is the joint and collaborative thinking, is that they don't have access to all the support they need, and which is just going to result in the provision not being provided to the young person and potential deterioration and return to a mental health institute, which no one would want to happen. That's a brief, quick overview of some of the situation, as I think I've highlighted by what I was just discussing. It is highly complex, many aspects interchanging with young people, especially, I would say, in this area. And it's the advantage of having assistance of people with needing to be aware of all different aspects that might apply and the assistance that can be obtained. I think that is the end of my presentation, and I would like to say thank you for listening.
Thank you very much, James. That was excellent. Obviously, the lack of proper commissioning of adequate provision for children who need to be accommodated with support it's obviously a complete national scandal. We've done other sessions about that, and I'm sure we'll hear more about that. Just on the question of the pros and cons of staying in under the Children Act, sometimes it can be great to have the continuity of the guardian, which of course you lose when you go to the court of protection, but just, there's lots of variables, aren't there, to factor in. So now we're going to hear from Felicity Williams, also a barrister in Garden Court Chambers. Felicity specialises in public law, court of protection and community care cases. That means she's got a particular expertise in using judicial review around the fringes of the limits of the jurisdiction of the court of protection. She's got particular expertise in representing young and vulnerable people in public law proceedings. Her casework includes deprivation of liberty, personal welfare and complex care packages. She's highly experienced in community care and Children Act judicial review claims. Doesn't say so here, but I also know that what Felicity doesn't know about accessing community care from prison isn't worth knowing. Which is so all of which assists her approach to court of protection matters. Take it away, Felicity.
Thank you so much, Amanda. I'll attempt to share my screen. So moving on from what James has discussed in terms of the pragmatic aspects of setting up a move forward for somebody moving out of Mental Health Act detention. The first issues are going to be building this basic framework for the transition, and in terms of the Court of Protection's role, looking at what care packages are available to the individual concerned. In many cases, and I've set out the basic frameworks in very short order there. The Mental Health Act 1983, Section 117, aftercare. Obviously, this is a joint duty on ICBs and social care providers, so local authorities. Apologies, I'm just going to change this view. For both the purpose of meeting the need arising from or related to a person's mental disorder, or reducing the risk of a deterioration of the person's mental condition. And most people, I hope, on this seminar will be familiar with that provision. Then there's provision under the NHS Continuing Healthcare, CHC provision. This is arranged and funded solely by the Health Service to meet physical or mental health needs arising as a result of disability, accident or illness. And that's under the NHS Responsibilities and Standing Rules Regulations 2012. And as somebody is approaching discharge, assessments will occur, and that can be in accordance with Section 74 of the Care Act 2014. And the relevant provisions there, the assessment process under the 2012 Regulation 21, planning under the national framework for the NHS continuing healthcare and NHS funded nursing care. Next, there's consideration of joint packages, and this is the situation where an individual may be ineligible for CHC funding, but the needs are clearly beyond the provision of the local authority alone. And at that point, there may be a joint package of care that needs to be provided. In those circumstances, when we're actively looking at proceedings and the evidence that the court will require, those who are bringing an application or responding to it will want to consider whether the joinder or participation by the ICB or trust is required. And that's often an issue which gives all of us some difficulty, because clearly ICBs are often reluctant to get involved at an early stage, but it may then become quite clear later, further down the line, that they are required in terms of providing further evidence and to be actively involved in the decisions that the court's approaching. So it's very important at an early stage to identify what the roles are of the bodies concerned and whether or not their participation is going to be required in order for the appropriate plans to be drawn up. Then there's the Care Act 2014 framework. And just for reference, I've set out the provisions there in terms of the assessment duty is Section 9, the eligibility decision, Section 13, and the eligibility criteria regulations, just for your reference. It's worth flagging as well that under the Care Act 2014, there's also provision for transitional assessments for support post 18. So looking at the types of cases that James was talking about for young people, often in the course of the proceedings that we're dealing with in authorising deprivation of liberty under the Mental Capacity Act, a young person may turn 18 and we see a lot of support and care planning fall away very rapidly. And it's really critical as these proceedings progress to ensure that the appropriate assessments are being conducted and followed up along the way. And then, as James has already referred to, there's the vast range of provisions under the Children Act 1989, and leaving care provisions, and all the relevant guidance applicable to children. It's beyond today's seminar to deal with that in great detail, but clearly a huge range of requirements there in terms of care planning for children in care and leaving care. Under the National Health Service Act 2006, Section 82, we have a clear cooperation provision. In exercising their respective functions, NHS bodies and local authorities must cooperate with one another in order to secure and advance the health and welfare of the people of England and Wales. That cooperation provision is reflected elsewhere in statutes upon other public bodies, and of course throughout local authority and healthcare guidance. But unfortunately, we often fail to see that operating in practice, and also often see a failure of handover between one public body and another as these individuals move from the mental health provision into other placements where they're required to have detention under the Mental Capacity Act. The Department of Health and Social Care has published guidance on discharge from mental health inpatient settings. This was updated in January 2024, and I've set out there, and I will leave it for you to read and consider in more detail the core principles that are said to apply through that process. But again, reflecting very much the emphasis that James has referred to already on the critical responsibility of the public bodies as partners to ensure that discharge planning takes place across those bodies, and to ensure that discharge occurs in a timely and safe way. So unfortunately, that doesn't always happen in practice. We see some very good examples of good practice, and then other areas where support just appears to fall away very rapidly, and that knowledge is not passed on from one set of care provision to the next, and that's often really critical, ensuring the success of future placements for P moving forward. Considering as a case comes to the point of the Court of Protection's consideration, clearly looking very much at the individual circumstances in each case. What are P's individual wishes and feelings? Helen highlighted very clearly at the end of her talk the importance of managing risk and ensuring that the most positive future is available to that individual moving forward. Looking at the history and the community and family circumstances. And again, the Care Act provision, Section 74, highlights the importance of that forward planning, stating that where a relevant trust is responsible for an adult hospital patient and considers that the patient is likely to require care and support following discharge from the hospital, the relevant trust must, as soon as is feasible after it begins making any plans relating to the discharge, take any steps that it considers appropriate to involve the patient and the carer of the patient. And of course, in many of the Court of Protection cases that we're dealing with, the role of the family and the engagement of the family in these cases is critical and can have a huge bearing on the success of a placement moving forward. And their knowledge of the individual and their ability to advocate on their behalf is essential in many of these cases. So early issues as these cases proceed. Capacity, James has spoken a little bit about this. What specific determinations are required? As Helen mentioned in her discussion, unfortunately, sometimes during the progress of somebody's detention under the Mental Health Act, the specific decision capacity decisions that are required aren't necessarily identified with great clarity and with separation that will be required going forward to authorise any deprivation of liberty under the Mental Capacity Act. So some real clarity of thought is required in relation to that. This was highlighted to some extent in that case of Wiltshire County Council and RB that I've set out there, the reference to. In that case, there was a case considered by Mr. Justice Peel on appeal from Her Honour Judge Cronin's decision. And the difficulty in that case was that the judge at first instance had conflated a capacity of P's consent to discharge with her capacity in relation to residence. So clear identification of what determination is going to be required going forward in relation to capacity is of great assistance. In terms of the statutory assessments for P moving forward, obviously there's the question of timing. I've highlighted there the case of PH and CCG. That was a case considered by His Honour Judge Burrows. At that point, the court was being invited to consider an application under 16 to authorise a future deprivation of liberty. And at that point, the judge was clear that it was essentially premature because P wasn't at that stage approaching discharge. So timing of the consideration and the planning and the evidence that's required has to be carefully considered. It should be said that in that case, the judge was also clear that there was no bar to the Court of Protection considering the issue. It was simply the timing was premature. In contrast, or to be considered in relation to that, is also the availability of planning documents. ND, the case set out there, dealt with a case where there had been repeated failures to prepare pathway plans for P, and the court was highly critical of the failure of the local authority in that regard. So yes, timing is a question, but at the same time, ensuring that plans are prepared suitably and quickly enough for the court to move on with authorisations is also key. In light of other early issues, we've seen the Section 74 provision with regard to carers that I referred to a moment ago. Obviously, carer assessments may need to be considered, and I've set out there the Care Act provisions in relation to the duty to assess under Section 10 to decide eligibility under Sections 13 and 20, and to make plans for carers under Sections 24 to 25. Another early issue may be respite provision. Again, this may be critical to the success of any placement for P when they leave hospital and move into alternative placement provision. So what respite is going to be available? If they're moving home, are the parents going to have sufficient respite? What are the placements being considered, and so forth. And then another consideration that we considered needed to be flagged is in the event that there has been a hospital admission and that all parties are aware of it, what steps have been taken on an urgent basis, or are the steps that still need to be taken in order to preserve P's property, his or her existing accommodation, and the benefits that they may be in receipt of, such as housing benefits. So when considering responsibilities and handover, four core questions that we will all be considering: what is the intended placement? Is it going to be a care home, supported living, a package of care in the community? Clearly the form of placement is going to dictate what authorisation is being sought, as James has referred to, whether this will be under DOLS or whether there is going to be a authorisation required from the court. What evidence is going to be required in support of the move? And at an early stage, as I've already touched upon, is a trust or ICB going to need to be joined to proceedings, or is the education authority required to be joined or provide input? And as James referred to, it may be that an educational placement is being considered, or a residential school, and or may have been involved in the past, or maybe returned to one of those locations, in which case it may be that the education authority or provider has very important or significant input to provide in the planning process. And then what are the handover requirements? Liaison and planning with the care staff and the health counterparts in the community. The knowledge sharing over the placements from move from hospital to a community placement can be extremely critical in terms of managing the least restrictive environment for P moving forward. So core elements of planning in terms of what's going to be requested from the court in terms of authorising any restrictions going forward. As I referred to, the form of placement and the care staff, what are the plans in terms of sourcing of the placement and the staffing agencies? What handover is planned, training that may be required. Frequently there's a suggestion that restraint isn't going to be an issue or isn't thought about sufficiently in advance, and then it becomes clear during the planning process and in the course of proceedings that in fact restraint is going to be used or will be unfortunately inevitable, and in that case has there been sufficient restraint training, and what is being planned in that regard. Communication again can be a key area in relation to the success of a future placement. What's happening in relation to P's communication planning, and anything that he may or she may need in terms of social stories and handover. So all of that support and planning is key. Then there's the actual health handover, who's taking over in the community mental health team or learning disability teams, what is the ongoing psychiatric or psychological input that's going to be provided, what contact has there been with GP in terms of making onward referrals, and also in terms of any physical health needs that the individual may have. And in terms of specialist input, SALT, OT, psychology, we're all aware that there can be a huge raft of requirements that need to be considered, but some of them can prove very key in making the placement a success. Activities, critical at all stages. Again, reflecting on James's comments during his talk, there can be it can be a very important part of a young person's placement and success of that placement, that there is appropriate community access, whether it's day centres, other forms of recreation, and that it's personalised to their interests. Certainly in a number of cases I've been involved with, a placement has been most at risk because there's been insufficient stimulation and engagement for a young person moving into the accommodation, and they end up not interacting with their care team, not having the access to the community they need, and that can often lead to quite rapid deteriorations in mental health and put the placement at risk. Family input, I've already referred to this. Their role on placements, it can be critical. If you have a family member that's heavily involved and very concerned about certain aspects of the placement, it can, as we've all seen, I'm sure, lead to risk of placement breakdown, and certainly communication between family and the practical situation of, you know, where's the placement located? Can they travel there to see their family member? And are they having a caring role? And as I've said, the necessary assessments need to be conducted in that event. Finally, two final aspects. Moving home, again, something that many of us may have seen is the need to actually consider what the new placement is going to look like. Are the belongings that can be moved in that are familiar to P, suitable furniture, can they have some engagement in what their new placement is going to look like, to personalise it, and make the whole process more settled and appealing moving forward. And then finances, what's happening in terms of deputy or appointee, are benefits in place? If it's one of the cases that James has been speaking about, is there a change in benefits when they're moving into over 18 provision, and has that been sufficiently planned? Again, we may all have seen cases where a young person is left with an allowance but not sufficient provision in terms of their benefits moving forward, and that needs to be considered at an early stage so that the placement could be a success. And then transport costs, again, both for the young person accessing the community and also in relation to family visits and motability vehicles and so forth. So there's a huge amount there to be considered, but all of which may contribute very firmly to making the placement a success. So I've just provided a final checklist, so I'm very aware of time. The things that the court are going to want to see in respect of authorising a deprivation of liberty under the Mental Capacity Act. Care plans, have the statutory care plans and the care placement plans been made available? PBS planning, what forms of restraint are going to be used? What's the staff training? Is it the least restrictive option moving forward? And is it necessary, or those questions need to be asked? Risk assessments, any specific risk assessments relating to P, possibly their access to the community, for example, are they safe in traffic? What about the placement itself? Are there specific risks to them that need to be considered? Communication, is there a requirement for communication, passport, social stories, in particularly in relation to enabling P to know about their transition to the new placement and what that's going to look like? Conveyance plan, how is the actual conveyance going to take place from hospital to a new placement? There's a lot that's been said on that topic. There's also specific guidance that's been set out by DJ Avis that many of you will be familiar with. But what needs to be identified is what plans have been made, who's going to be responsible for the handover, who's going to take the lead, how is it going to happen on the day, is sedation or restraint required, and how is it going to be monitored through the move. So those issues all need careful consideration. The day of move plan, I've set out there the considerations for actually sort of broader considerations for how that move may take place. And then activities, weekly planners, and often you receive something that looks very full in terms of pictures. You often get it in pictorial form, but what's actually going to happen on the ground? Is P going to be sufficiently engaged and active in the community and have enough interest at the placement? Hand in hand with that, education, is there going to be tuition at the placement? Does P have an EHCP? As James has underlined, this could be really important and can be maintained up to the age of 25. So is that EHCP in play? What are the contingencies and crisis plans? What's the respite plan? And then finally, as many of you will have realised, the court will often require a restrictions list, a specific identification and list of restrictions that are going to be required to be authorised by the court, including during transition and under the care plan. And again, although this should have been considered at the outset, are there any specific capacity issues arising, for example, over internet use? Okay, well, that was a speedy whiz through the issues there. Hopefully that was of assistance. Thank you very much.
That's excellent, Felicity. Thanks very much. We've got a few minutes left. And I'm going to read out a question we've got here for Felicity from Lynn Hull. She says, I have a case where a person is currently living in one local authority area, but their section 117 aftercare is the responsibility of another local authority. The issue is that the responsible local authority is stating that the person's needs are not aftercare needs. Oh, that old chestnut. I am presuming that no application can be made to the Secretary of State as there is no dispute regarding ordinary residents. I'm not clear what legal process the local authority could follow, except taking the matter to court as a last resort. The responsible local authority is not being very forthcoming with providing any information or agreeing to a meeting to discuss. Have you got any thoughts? So it's a dispute over who the responsible local authority is. Felicity, what do you say?
Well, obviously this has been the subject of considerable court consideration. It doesn't sound helpful that you're not receiving all the information about the background, but it should be fairly, well, I would obviously need to see the facts of the case and have a bit more detail, but depending on where they've last been in receipt of Section 117 aftercare, then gone into detention, there may be a duty arising there once they leave, but unfortunately I don't have enough detail on the face of it to provide advice in the course of the seminar.
No, that's a fair point. I mean, those disputes are often, especially when you've got neighbouring local authorities, those disputes are often dealt with by way of informal, similar to arbitration agreements between local authorities. And it's good to know whether the local authority is concerned have got an informal way of resolving those kinds of disputes without embarking on costly litigation. Maybe Helen has got something to add to that, because I know that this is something Helen's had to grapple with on numerous occasions. Helen?
But thanks, Amanda. I didn't mean to sort of flash the plaster about my injury, but forgot about that when putting up my hand. After the Supreme Court decided in the Worcestershire case, there's now some statutory guidance, but the primary point is that if it's P or the patient, if it's not someone who lacks capacity, someone who is a patient, it's their needs which cannot be ignored. So even if there is an ongoing dispute between the local authorities as to who's going to pick up the bill, the emphasis and it's reiterated in the guidance, is that leaving ordinary residents aside, it's the person whose needs are present. Those needs are primary and they have to be met. So the local authorities, plural, are going to have to come to an arrangement whereby those needs are not ignored or disregarded while they fight it out.
Yeah, no, fair enough. And obviously, you're going to want to get a provision of all the Section 117 aftercare planning. The same isn't always the true when you're looking at an assessment under the Care Act and eligibility and that sort of thing. So you've obviously got that. You're right. I mean, obviously, you're right that if somebody's in your area and you've got care needs, then obviously there has to be an assessment. They have to be met, whether or not there's a dispute over Section 117. That must be right. Right, we've got another question here from Mary A.O. What steps do you take to preserve P's property and benefits? Now, that I'm sorry to come to you again, Helen, but that's something that you often deal with.
I don't know, Felicity sounded like you were going to say something, but certainly there should be an appointee in place, either through the client affairs department of the local authority, if there isn't a family member who's already an appointee, so that the benefits are accumulating and not just lying there unclaimed. Property, if it's that's, I mean, it's all, there's no hard and fast answer to that, because it depends where the property is, who has ownership of it, who's involved in looking after P's or the patient's belongings. Felicity, you've put your hand up, and I know that there's a question higher up the.
Also, I was only very briefly going to say that I think the key thing that I was thinking of there was are repossession proceedings being sought And if the local authority is aware of that and aware that an application is being made to the court of protection as well, that the local authority should clearly be informing the county court that that there is a capacity issue and that these proceedings are taking place, so that the property is not disposed of in the meantime.
Sure, I sort of interpreted it as sort of personal effects rather than an actual property, but certainly usually any possession proceedings are stayed whilst the currency of the court of protection proceedings has an option of a return home in the background, and often orders will recite an obligation or the intention of the local authority to secure the property so that it's retained in good repair. There's a question, Amanda, don't know if you've seen it, just higher up at the very top from Josh Horn, which I think about, he says it's a question for the end. So
I haven't got that one in my chat. I don't know why.
Oh gosh, well, I'll read it out, and I know that James is going to provide the answer. But the question for the end, thank you, Josh, for your question. When moving from long-term detention under the Mental Health Act onto the DOLS framework, in particular the community DOLS framework, who is responsible for the application, and what are the average timeframes to ensure the smooth transition of legal frameworks? We're worried one of our clients will fall between that situation, fall down the middle with no one taking responsibility. So James, I think you've got recent experience of this.
Yeah, so my recent experience is that Judge Hilda dealt with one for me. I think the application was made it tried to be done under re-ex procedure. Judge Hilda took it out of it. Judge Hilda heard the first hearing I appeared in front of Judge Hilda was in December. The hearing when they approved the community DOLS provision was end of March, and then all we're now waiting for is the Mental Health Tribunal to approve it. And Judge Hilda's comment, I don't think she would mind me repeating, is that sometimes before the tribunal makes their decision, a responsible clinician has already let the person out. So you don't actually have to wait for the Mental Health Tribunal. So the thing that slowed my case down, or not slowed it down, is it depends how quick the capacity assessments get done. It's all the other bits and pieces around it. You can get hearings as fast as possible. And I think in respect of long-term detention, Mental Health Act, etc., how it's transferred is there's a responsibility really under 117 that the package should be put in place before the patient is discharged. But for community DOLS, it was the local authority. The local authority is responsible, and they manage it. And it's raising it with them to make the application and reminding them they need to do it. I hope that answers the question.
Yeah, thank you for that very succinct answer. Was there anything you wanted to add, Felicity?
No, sorry, probably lost track.
Not at all. Just going back to Mary Ao's question, it's inescapable that in some cases there are going to have to be property and affairs applications made to the Court of Protection, and that obviously raises a difficulty because last time I looked there was no legal aid for that. So yes, but it may be something that local authorities need to be on top of when looking at safeguarding P's financial as well as other interests. Well, we've come to 6:31. Excellent timing, everyone. I just wanted to say that we've got two upcoming events I've been asked to tell you about. The first is on the 9th of May, 2024, and it's Criminal Law and Human Rights with Professor Leslie Thomas, KC, and Professor Dimitrios Giannolopoulos. I hope I said that correctly in conversation. And then on the 14th of May, to celebrate 40 years of UNCRC, we've got UK Children's Rights Day, Upholding Children's Rights, and we have a very eminent panel talking about the differentiated implementation of the UNCRC as compared with England, Wales, and Scotland and Northern Ireland. I'd just like to thank all of the attendees for joining us. Thank the speakers for all the work they put into those presentations, which were intensely informative, and I'm very grateful to them all. We appreciate your feedback, so if you are watching online, a feedback form will pop up when the Zoom ends. Please do fill this in and let us know what you think if you're able to, and we will send a link to all the recording and slides. And with that, good evening, everyone.